Ready, start. According to the case of the appellant in Civil Appeal number 10899 of 2013, pursuant to a public advertisement and selection process conducted by the officers of the IAF on 1st July 2005, he was appointed as a trained graduate teacher in the subject of physical education in the said school. According to his case, he was appointed on probation and the probation period was extended from time to time. On 28th June 2007, an order was served upon the appellant stating that he was rendered surplus as the said school decided to appoint a more qualified teacher. An option was given to the appellant either to remain employed in the said school on contractual basis on a fixed salary from 1st July 2007 to May 2008, or to remain employed under the existing arrangement under which his service would come to an end on 3rd July 2007. Therefore, the appellant filed a writ petition before the single judge of the High Court, inter alia, praying for a declaration that the appellant is confirmed teacher in the said school. The writ petition was allowed by order dated 13th January 2010 by a learned single judge by holding that the said school was a state within the meaning of Article 12 of the Constitution of India and was amenable to the jurisdiction of the High Court. Learned single judge, after setting aside the impugned orders, observed that it will be open to the society to consider the claim of the appellant for confirmation in accordance with the law. An appeal was preferred before the division bench, essentially on behalf of the management of the said school, which was allowed by the impugned judgment dated 12th July 2010. The division bench held that the said school was not a state within the meaning of Article 12, and as a result, a writ petition under Article 226 could not be entertained. Hence, the judgment of the learned single judge was set aside. The appellant Sanjay Kumar Sharma was appointed as a postgraduate teacher on 19th June 1993 and was later on confirmed by the officer in charge of the said school. The officer in charge was an officer of the IAF. On 3rd March 2003, he was appointed as the officiating principal of the said school by Wing Commander Ajay Kumar, officer in charge. According to the case of the appellant, the sixth respondent, Shrimati Shalini Cole, has started acting as the principal without taking over charge of the post. Disciplinary proceedings were initiated against him by the sixth respondent. Later on, at the instigation of the sixth respondent, girl students filed a complaint against the appellant. On the basis of various allegations, a show cause notice dated 19th December 2005 was issued to the appellant. On 23rd February 2006, a charge sheet was filed against the appellant. There were two writ petitions filed by the appellant. First was the writ petition number 12437 of 2006, wherein the appellant sought to challenge the appointment of the sixth respondent as the principal. Writ petition number 19915 of 2006 was filed by the appellant for challenging the charge sheet dated 23rd February 2006. By the order dated 5th July 2006, though the learned single judge held that petitions are maintainable, it was observed that as disciplinary proceedings were pending against the appellant, no interference should be made. Stop. There are two special appeals preferred by the appellant for challenging the judgment dated 5th July 2006 of the learned single judge. Stop. By order dated 11th September 2006, the order of remand was passed by the division bench of the High Court to the single judge. Stop. The single judge, by his order dated 16th September 2010, dismissed the writ petitions by relying upon the judgment impugned in Civil Appeal number 10899 of 2013. Stop. Thereafter, the appellant was terminated from service. Stop. A special appeal were was preferred by the appellant against the judgment and order dated 16th September 2010 in writ petition number 19915 of 2006, stop, by the impugned judgment and order dated 2nd November 2010, the division bench dismissed the appeal on the ground that the writ petition was not maintainable. Stop. The learned single counsel appearing for the appellants submitted that the primary function of the Air Force School is the promotion of education, fine arts and culture, mainly amongst the past and present employees of the IAF, their families and children. Stop. The learned senior counsel submitted that the documents on record clearly show that the Air Force headquarters exercises dominant control over the administration and functioning of the Air Force schools. Stop. Learned senior counsel relied upon an application made by the said school to CBSE for affiliation, in which the said school claimed that it was fully financed by the IAF. Stop. He submitted that all Air Force school buildings have been constructed using public funds under the authorization of the Ministry of Defense. Stop. He submitted that the pay scales of the school staff are fixed by the Air Force headquarters, which is the appropriate authority. Stop. The command schools management committee has to conform to the pay scales as issued slash recommended by the Directorate of Education, Air Force headquarters. Stop. He also pointed out that the command schools management committee has been constituted to run Air Force schools in accordance with the rules and regulations specified in the Education Code of Air Force Schools of 2005. Stop. Inviting our attention to the findings recorded by the division bench of the High Court, he submitted that the High Court had committed an error in holding that there was no material on record to show that the said school had been set up by using government funds and that it was not established that the institution is not governed by any statutory regulations. Stop. He submitted that there is enough material on record to show that the IAF exercises deep and pervasive control over the said school and, in fact, over all Air Force schools. Stop.